Welcome, everybody. We're going to give people some chance to join us today. If you can see us, if you can hear us, please say so in the chat. Give us a little hello so we can monitor that people are here. I see Amber's here, but I already knew that. Here we go.
All right.
Okay, so everyone can, so this is Lisa. My audio is good, yes? Okay, Elizabeth, Amber, test.
Yep. Hi, everyone. Thanks for joining.
Okay, we're going to give it a minute for people to join. Give it a second. If you're here and you're in the chat, let us know where you're from, where you're at right now, so that we know who we're talking to.
Let us know what you're eating for lunch.
Is it lunchtime? It is lunchtime. This
Yeah.
Technically a lunch and learn.
Okay, so that's 11:01. So we're going to go ahead and get started. So welcome everybody to Protest Proof Your Proposal, common technical proposal issues that could lose you the award in protest. Thank you so much for joining us today. This is actually part 2 in a series. We did the first part late February before the world turned upside down with coronavirus in person. So while we would have loved to be in person with you having lunch, this is the next best thing. You can see our faces, we can have a discussion. And so we're just going to move on with giving you some really good advice on how to avoid some of the common pitfalls in proposals that might lead to a protest. So let's get started. So who are we? I'm Lisa Shea Munt, the co-founder of the Pulse of GovCon. And with me, I have these lovely ladies, Elizabeth and Amber. If you could please introduce yourselves.
Hi, everyone. My name is Amber Hurt, and I'm also the co-founder of GovCon, the Pulse of GovCon, not GovCon in general.
Just in general.
That's impressive. We have the founder.
Very tired.
Yeah. Hi, I'm Elizabeth Jokum, and I'm a partner at Smith Pachter McWhorter, and I practice in government contracts law, which obviously involves a lot of bid protests. I also do counseling for government contractors on compliance issues, advising on subcontract and teaming agreements, and basically any kind of GovCon-related litigation. But today we'll focus on the protest side.
Right. So we are all GovCon all the time. That's what you guys are here to see today. So we have one objective for today's Lunch and Learn, and this is the discussion on common proposal development pitfalls that could open you up to losing a protest. Now, we're about to have 2 disclaimers, the first of which is going to be on the proposal side, which is Amber and myself. And that's that the title of this series is tongue-in-cheek. Can you fully protest-proof anything? No, of course not. There are things that you can do to help mitigate some of these issues, but many, if not most, protests are won because of errors made on the agency side in the course of its evaluation. So even if you have the most perfect proposal, it can still result in an overturned award if they didn't follow the ground rules of the solicitation and treat offerers equally. So that is our proposal disclaimer.
And since I'm an attorney, I had to add my own disclaimer, but this one is particularly important. So as many of you probably know, if you file a protest or are involved in a protest at either GAO or the Court of Federal Claims, they will likely issue a protective order, and that protects the proprietary information of the parties to the protest, and it allows the protester and the intervener's attorneys to see all the proposals and all the proprietary information, but not the companies themselves. So as attorneys, when we apply to admission under a protective order, we have to make a representation to GAO or the court that we're not involved in competitive decision-making for any company that could gain an advantage from the protected information that we're going to see. So that generally means that attorneys that do bid protests can't provide advice on pricing or competitive structure, any proposal development issues really, since we may have had access to your competitor's proprietary information. So first, of course, no information that's subject to a protective order will be shared during the presentation. I'm only going to be talking about publicly available information from published decisions. And then only Amber and Lisa will provide actual advice on proposal development. I'll talk through, I'll provide my insight on these protest issues and trends in bid protests, but no actual proposal advice.
Wonderful. Okay. So we're going to be talking a lot about compliance, and I'm going to get into this in a hot second. But first and foremost, we'd just like to say that the format of this presentation and the space that you guys are in now, you might have already noticed that you have the chat function. Please feel free to write in the chat if you have anything to add, if you have any questions. Amber Hart will be managing the chat room today. And this feature also has the option to add formal questions if you scroll down in your screen. So if you have a formal question that you would like to submit, please feel free to do that as well. If there's anything that you want us to elaborate on, stop us in either the question or the chat function, and we'll be happy to take a break and discuss what you want to hear. But first off, we're going to talk about the impact of compliance, because when you're talking about proposal development, proposal management, how can you avoid this topic? Amber and myself, we are compliance literalists, and we believe that is the easiest tactic to prevent a protest loss because of something within your control. And that's going to be the general theme of all of the proposal information and development stuff that we're going to be talking about today. Because we know that agencies and the government and the source evaluation board, the source selection board, whatever it is, they work hard to create processes and procedures to evaluate bids fairly and objectively. Nobody is bashing the government here, but at the end of the day, they are trying to translate qualitative data into a quantitative scorecard, and they are human, you are human, we're all human. So there is human error here. So some people say, well, aren't rules meant to be broken? And since we are literalists, no, they're not in proposals, because proposals in their truest form are an exercise in following direction. And so some of the stuff that we're going to be talking about today, you're going to say, yes, of course, that's what it said in the proposal instructions. But Amber and I have been proposal consultants and in proposals for 10 years, and the amount of pushback that you get from executive leadership, from management, to go outside of the realm of what the solicitation is asking for, it's insane. And it happens everywhere. It is completely ubiquitous. It doesn't matter if you are at a systems integrator. It does not matter if you are at a mom and pop shop. We always believe when it's our work and it's our contract that we know better than what's being asked of us. We know that the technical requirements are important, and so is showing differentiators. But what turns out to be equally as important is just making sure that you follow the instructions to the letter of the law. So this is what we're going to be talking about today. We've broken it out into three main categories. The first of which is going to be failure to meet contractual requirements. The second is going to be key personnel issues. And then the third is going to be one of my favorites, which is going above and beyond, which is in some cases a good thing and in other cases hugely detrimental to your bid. So let's get started. Failure to meet contractual requirements. This is sometimes requirements that are included in an administrative law. And we're here to tell you that these requirements are still requirements. Just because they're outside of the technical approach, the management approach, some people completely ignore the administrative requirements. Amber, do you agree with this?
Yeah. And it's unfair because some of these things are outside of your control, right? Like, let's talk about the SAM registration. Those are a little bit more in control now, where you can send in the update, but it takes the government to approve and process them on the back end, right, to get that up to date. And that should be with the click of a button, but it's the federal government, so it's not. Your CPARs, right? PPQs, all of these things that we're going to discuss, right, that are administrative requirements. Signatures on your contract documents where the government should have signed them and they didn't, or you didn't get the updated copy or mod. These are things that are technically in your control, that is also depending on the government, but at the end of the day, you're the one responsible for them.
So Maureen, you ask a good question. You say, are these requirements in a specific section or sprinkled throughout? Most often they are sprinkled throughout. So reps and certs is an example. Anything in section G, which is contracts administration, that seem to be sprinkled in requirements that you actually need to include in your proposal, but might not have known unless it specifically says in section L to reference section G. It can be that. It can be, like Amber said, SAM registration being up to date. It can be having the right SF-33 sign. amendment. I mean, these requirements, I wish that they were just in one section. Even if they don't require an administrative volume, typically you have to fill these out as well.
And you always ask a question. If you come across a document, I'm sure Elizabeth would agree with this. If you come across something that's in your solicitation in any of the sections that looks like you may need to fill it out and it's not in section L or section M, ask a question, because administrative requirements are the one thing that will get you booted so fast. And, something we didn't talk about too, administration, is also how you label your documents, how you format them, what you put on your CD covers, because unfortunately that's still a thing, how your table of contents is created, your cross-reference matrix. All of that is following directions. And if you have any questions about anything administrative, don't just say, well, they'll be okay with this, because we've seen plenty of people, including, clients of our own, that have been booted for failing to follow the instructions. And always asking the question is the best way to mitigate that.
I'll never forget.
Yeah, I think, Maureen, one thing to note is I think that when the requirements are in a specific section, it's actually almost more dangerous. Because if they're sprinkled throughout and the RFP is disorganized, then you're going to go page by page, line by line, and try to figure out what your requirements are. If it appears that they're all in one section, then you're probably going to be a little less diligent. But those are the ones where there's, tricky requirement in some strange section that you didn't notice, and we're going to try to notice it during the protest and say, well, you didn't comply.
Mm-hmm.
Right. I know there's one example of a team that I once heard that put out they replied to a standard GWAC. They were a small business and they filled in the small business version of the template they filled in the large business version when they were a small business. And the only difference between the documents was that it said large business or small business in the header. And that was the difference. And they got thrown out. And they tried to protest.
You may be thinking like, hey, that seems like a really simple thing to not make the mistake. This was not my team, but I know what one she's talking about. But this was a GWAC that had 33 amendments over the course of a year. I'm sure we could all guess what maybe one this was. But it gets like that, right? Where you're on amendment, 25, everything is, your eyes are crossing. The documents are all over the place. Staying organized and asking questions and always double checking is the best way to mitigate that.
Well, and they did protest, if you remember, and they lost because GAO said, no, you filled out the wrong form. The instruction said, fill out this form. And they said, but that's such an administrative requirement. And they said, yeah, we don't care.
Yeah. Yeah. So on the case law side of this issue, I mean, there are, I say numerous, there's a million examples of protests where GAO or the court upholds an agency's decision to exclude offers from consideration for failure to meet these types of requirements. So, and Lisa just mentioned one. If you get booted, you're going to have a really tough time clawing your way back into the competition through a protest. Registration on SAM is a big one. And I'm actually finding that this registration on SAM issue is becoming more pervasive because of the All Small Mentor Protege program. So companies are forming joint ventures that are opportunity specific. All those JVs need to be registered on SAM. And sometimes the proposals say they need to be registered at SAM prior to award. And sometimes they say at time of proposal submission. So I don't think necessarily every offeror realizes the JV itself has to be registered, not just each of the JV members. And then again, you always have to be looking at what is the language in the RFP and when does the requirement actually kick in. But so if you're excluded for failure to register in SAM at the time of proposal submission, and that was a requirement under the RFP, I mean, this case, GAO didn't even consider their protest. They dismissed it because they said, basically, you're not an interested party. You already got booted. So,
right.
Yeah.
It's funny that they would because I know that it will say in some solicitations that you must be registered in sam.gov, but you also just need to be registered there to do work with the federal government. So I don't know what they were trying to do by protesting that. If you're not in SAM, you're not in SAM. And I would like a quick caveat here too. If there are any small businesses here or anybody starting out, please don't pay somebody an exorbitant amount of money to register you in SAM. It's something that we've been noticing. There's a bunch of scam artists that try to flit around and ask for 5Gs in order to fill in your information in the system. don't do it. That's just my 2 cents there.
And if I could throw something in there too about Sam and Elizabeth, I know you said that you're noticing, right, kind of the uprising in this, and something to also keep in mind, because I think a lot of our attendees right now work for bigger integrators or company where you might not be experienced in creating a sam.gov profile. The requirements in creating one has become a little bit different. You used to be able just to kind of register and it would pop up there and that all would be fine. They now have requirements where there's someone on the back end kind of vetting the information, sending you questions, and you have to send in a certified piece of paper that's been notarized and by mail to the government and have them check. And especially in the time of the pandemic right now, that timeline has increased. And there's some caveats where they're allowing you to have kind of an interim sam.gov profile. But as you're kind of creating JVs and things like that, there's a lot of times where by proposal submission, you have to have this in place. Understanding the timeline of these and kind of working with your contracts department immediately or your legal is something that you need to start immediately, because it's not something that you just go in and you register for anymore. It actually takes some time.
I do think, people tend to get most jammed up when this requirement is triggered at time of proposal submission. But given the long lag times right now, even the at time of award requirement is problematic. I mean, you can do everything right. You can have everything ball rolling. You should be good to go by award. And if they make award quickly, there's some kind of delay, in the SAM system or with the agency that's running that, then you could be the presumptive awardee and then be ineligible at that time because your entity is still not registered. Mm-hmm. The next case I wanted to talk about, veteran technologists. I think it's a brutal one. So the protester here had failed to submit signed versions of each amendment. Kind of standard, super administrative requirement, not substantive at all. But it was a gate check requirement, and they got kicked out. And GAO said, that was within the agency's discretion. It was a mandatory requirement.
Now, that being said, will they always kick you out for that? No. Some contracting officers are really nice and laid back, and they'll let you know, hey, I need you to sign this, even if it's after the due date, because I've seen that too, and it's given me heartburn. But because I'm like, you didn't sign it, and they thought they said it was allowed. But if somebody were to protest, if they had won, you'd be completely opened up to that.
Yeah. And Elizabeth, I have a question for you just from a proposal management standpoint, right? When I'm working on a solicitation that might have, let's say 6 or more amendments on the regular SF, right? It has kind of that line where you can kind of put the amendment and say that you acknowledge it. Mm-hmm. So say the government asks for signed amendments and doesn't really specify filling that part out. Say you have under 6, if you were just to fill out that part of the SF-33 and not send back the SF-30 with the signed amendments, I have 2 parts. Does that count? Like, would that be deemed compliant? And then my second question would be, if there is more than 6 amendments, right, and you have to kind of carry over to a new SF-33, which you need a continuation page, is that more helpful, or should you still fill out and sign all the separate amendments, or should you do both?
Yeah, I don't think I've seen these forms closely enough to be able to say, in what circumstances you could or couldn't use those. I mean, my guess is that whatever the agency decided to do, GAO would allow. Mm-hmm. If the agency decided to say, oh, we looked at what you did and we find it non-compliant, is GAO really going to say that was unreasonable? It's hard to say. Again, you just go back to trying to do whatever is most compliant with the wording of that RFP. And if it's not clear, then you should ask a question.
Right.
It's just, yeah, exactly. Jeff.
Ask them what they say.
Yep, that's the advice. I mean, if you're not sure, if you're unclear about any aspect of an RFP, you got to ask the question.
Mm-hmm.
Right. And this is because people like you, Elizabeth, right? You're going to review these proposals for these type of non-compliances, and you can point it out so that you will be eligible for award. So,
yeah, I mean, that's sort of a gate. That's our gate check, right? So you can get through the agency's gate check. Congratulations, you're the awardee. You're being protested. Me and my team representing the protester are still going to go through your proposal and compare it to the RFP and say, oh, well, they didn't do this. Hello, lights.
You don't exist in there right now.
Anyway, yeah, so we're gonna, it's a second round of review. Now you have protesters council trying to figure out how to get you kicked out again. So
absolutely. So that was all the kind of contract administrative requirements that you might see. Now we're going to talk about key personnel issues, because and this drives Amber and I nuts. Some companies believe that personnel stipulations are guidance and not rules. And this is hugely false. This is things like years of experience, whether you have an active clearance, any certifications that you might have. You are in danger if you submit resumes, key personnel that don't meet the requirement, that have exceptions or you've made assumptions based on the years. And look, this is something people do, but you're still putting yourself at risk. So if you say, okay, my person doesn't have a master's degree, but they have what we would consider an equivalent at, say, 15 years direct experience and management experience, that's an assumption that you're making that the agency is going to say, oh, yeah, that's fine as a substitution. So you're putting yourself at risk there. If they weren't available or weren't consulted, when Amber and I started out, we didn't realize, when we were starting out in proposals, where do you put a junior proposal person? On resumes, on past performance, because for whatever reason, people think that those are a little less than in terms of the proposal hierarchy, and that. So we'd be working on resumes and we'd have the contact information for people that were being submitted. So we'd reach out and we'd say, hey, can you give us a little more detail on this job, and this job? And our favorite response was, who the heck are you? What is this for? What do you mean I'm being submitted for a proposal? I never agreed to that. That's not okay. And then, of course, our favorite, the bait and switch, which we're going to be talking pretty extensively about.
Yeah, so Lisa mentioned, key personnel that don't meet requirements. Again, this is a situation where this is an objective requirement of the RFP, if there's a degree requirement or years of experience. So even if the agency decides to accept your statement that he has 20 years of experience and that's equivalent to a bachelor's degree, that doesn't mean that you were compliant. It means that the agency essentially exempted you from a requirement of the solicitation. So there are several protests sustaining challenges to awardees that did that kind of substitution. So in Deloitte Consulting, the protester had shown that there were multiple proposed people that didn't meet the minimum qualifications. And what the awardee in that situation had done was put one of those little boxes that you all put on your resumes saying, check, 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 they have it, they have it, they have it. But when you dove into the resumes here, it was clear on the face of those resumes that they didn't meet those qualifications. So the agency just hadn't gone to that next level review, and protester council found it, and GAO sustained the protest on that basis.
Who amongst us is guilty of putting disingenuous check boxes on a resume? Oh, yeah, they got it.
Or maybe like fudging the years of experience a little bit. Something that we've seen a lot of is where it's counting the actual experience versus the total professional years of experience, right? Doing something. And, that might be really technical. And it's like, okay, this person has 20 years of professional experience, counting maybe their job when they worked in retail, or say they worked, they did something like in teaching, right? And then they decided to do a career change. That's overall professional experience. But how about working on ISR systems where they have 1 year of experience, right? And so we see that all the time where you're like, but they have 20 years of professional experience. Yeah, but not the technical direct experience. And it is so critical to count those years because, you'll get away with it a lot with the government, right? But if someone protests, they're going to be counting every year down to the month of how experienced those people are and if they really count. We have seen that so many times.
Yeah, and we're going to be a broken record in saying this, but if there's ambiguity, ask a question. So I saw one Q&A that came up recently where it was a highly technical position, and there were people that were being proposed that had basically, the phrase that you rise above your level of competence. Mm-hmm. So the the offer was essentially offering overqualified people who had moved on beyond those highly specialized positions to be program managers, deputy PMs. And they were concerned that the agency wasn't going to count those management years. And the agency actually did confirm that, no, we don't count management roles overseeing the specialists as years of experience in that specialization. So, that's a highly specific example, but if they had submitted it as they had planned, then the agency said in Q&A, no, that wouldn't be sufficient for us.
Well, and it's funny you bring up Q&A because a lot of these too is like better to ask forgiveness than for permission for some of these. And you'll see that a lot with key personnel. And that's why you'll see in Q&A, like, why would somebody ask if our program manager needs a PMP? It's because their program manager has a PMP and they want to make sure that you're excluded if yours doesn't.
100%.
Okay. Contingent hires.
Yeah, there's a lot of interesting case law on this. I think Lisa and Amber both hit on it already. Misrepresentation is the biggie here. I mean, if you are misrepresenting communications, either communications with or commitments from contingent hires, particularly incumbents, this is a huge protest issue. So everybody who wants to unseat an incumbent is talking about incumbent capture in their proposal, right? But there are ways to do that without overstating the extent to which contingent hires have committed to you. If you do overstate or misrepresent, it's a really easy way to lose your award. And you have to think about the fact that incumbents are the most likely of any offerer to submit a protest. So they're going to say, their lawyers are going to be looking and saying, well, look, they proposed 100% incumbent capture. Well, my client's employees told them that they hadn't signed any contingent hire letters. I mean, it is very easy to find these misrepresentations. And I think companies think, oh, I'll never be found out. How would they ever know? This is how they'll know, because they will protest their incumbents, and happens.
No, it absolutely does. I've seen 100% of incumbent capture constantly. It's anytime you have that good a number too, people are going to look into it. That's kind of a proposal trick.
And Maureen brings up a good point, right, about like some acquisitions where they're 1 to 2 years of time of protest, right? And these folks disappear even if they sign letters. And I think we get to that in the next slide, right, where we're discussing kind of legality and how do those letters hold up. So Maureen, we're definitely going to get to your comment. But with contingent hires, right, and misrepresenting, we see people that all the time are like, this is, they give a really ambiguous staffing plan, right? And here's how we're going to do it. And we have the incumbent, but we're also, but no kind of backups. Have there ever been in a place, Elizabeth, where you've kind of seen the staffing plan where it doesn't really say anything at all and that's gotten someone in trouble?
Yeah, it's almost a different question. So when people do propose incumbent capture plans, the agency is evaluating those plans like it would anything else, any other technical approach. It's saying, does this sound like a reasonable plan? So they might look at the labor rates that are being proposed compared to the incumbent labor rate. So if it's much lower, then is this incumbent capture plan realistic? So they'll look at the incumbent capture plan that you're proposing, or the staffing plan in general, as a technical approach and evaluate it separate. Things get tricky on key personnel and bait and switch when they haven't been vague. They've been extremely specific and identified people by name and indicated that they have the ability to provide these specific individuals.
Makes sense. And I just had something kind of pop up into my head that's a little bit of a aside from this, but just a question from a legal standpoint. So when you have a really large incumbent recompete, right? And I remember talking to recruiters and people in charge of staffing where it's like you want to go and you want to target the incumbent, but you're not supposed to, right, reach out to them during business hours, right? You're supposed to reach out to them that's what I remember hearing from a lot of recruiters where like that was like a law. Is that a law? Like, is that or is that more of like an ethical rule? And have you ever gotten someone in trouble for doing this? Have you ever seen that come up?
Yeah, I mean, I'm not an employment lawyer. I'm not familiar with that law. My guess is that their employers don't want them talking during business hours.
Or the government doesn't want them talking to other people about another job.
Right. I mean, the recruiters are probably just trying to be somewhat respectful of not trying to get them in trouble or putting them in a bad position. If a recruiter calls someone at 3 p.m. and they have to answer and they're right in the middle of the government facility, that person's probably not going to feel great about that recruiter. But yeah,
makes sense. I just remember always hearing that. Oh, we just had a great question. Can incumbents prohibit staff from talking with challengers?
So the executive order about incumbent capture is constantly in flux. My understanding right now is that there's not necessarily a requirement for an awardee that unseats an incumbent to give a first right of refusal offer to the incumbents. So therefore, an incumbent could have all their employees sign, standard non-compete, saying that they couldn't go to work for a competitor. Non-competes are tricky. Courts don't like them because courts don't like to make people be unemployed for long periods of time. So, if you're with one company and has a contract and that company loses the contract, the court doesn't want you to have to sit around unemployed for 4 years because you signed a non-compete agreement. Yes, an incumbent can try to not prohibit staff from talking with challengers, but to indicate, hey, you're not allowed to go work for any competitors, and we do enforce that provision of our employment agreements. It's not a clear-cut yes and no, but any employee who's considering signing a contingent hire letter with a competitor should definitely make sure to go back, read their employment agreement, talk to an attorney if you're concerned, but just make sure that there's nothing in what you've signed with your company that's committed to not engage in that kind of behavior.
Good. Oh, and yeah, that was our slide on incumbent capture.
Yeah, no, actually, this is a different one, but we did cover it a little bit. I mean, I actually, I think from a protest standpoint, if incumbent capture is your approach, you're better off talking about it from a proposed staffing approach position and be explicit about what your plan is. And you can talk about, in previous contracts, we've had this percentage of incumbent capture, we've been able to demonstrate in the past that we can succeed at doing this. That's all perfectly well and good. What you can't do is overstate the extent to which you've communicated with or gotten commitments from incumbent employees. As I said, I mean, they're going to protest. You're going to be found out. So you can be specific about your plan without being specific about individuals.
Mm-hmm. That makes sense. That seems like a better idea. Yeah.
Great. Okay.
Right. So, I mean, this is just kind of the pull quote that stands out to me. I mean, you need something more than, winging a prayer that these people are going to come work for you. Even if you're completely sure, you're like, this guy has worked in this role for 30 years for 5 different contractors. We know he's going to come work for us if we win. You still can't represent that he will unless you've spoken to him. So just
spoken to and gotten something signed, right? Like that. So let's talk about letters of intent and letters of commitment and like maybe a little bit of what the difference is, what you would use it for. Sometimes these are requirements in a solicitation. Other times they're not. And I know some people, even if they haven't asked for it, will try to get these to represent that they have some level of commitment in this way, right? Where they can say, this isn't just a hope or a belief. This is, we have this signed. And so I know Elizabeth and Amber, we had talked about this by ourselves about what the difference was, what it really meant, if they hold water, if people can sign multiple LOIs and LOCs. So do we want to kind of dive into that a little bit?
Yeah, although it might make sense to do bait and switch and then loop back to it, because I think some of these issues come up.
Let's do it. Bait and switch time. We've all seen the bait and switch. They generally have it as a clause in solicitations now. They don't always, but even if they don't, this is generally a frowned upon practice. And so this means that
in
general. So this means that you've represented that somebody that you have presented and you have proposed on the proposal side of things will work the project with no actual intention of them being there. Sometimes this is your executive management. I've seen that a lot, especially in small businesses. oh, I'm going to propose our COO as the PM. There's no way they're going to be able to PM, but look at their qualifications. Beautiful. Mwah. Love it. Bait and switch. Now we're going to talk about why you don't do that.
Yeah, and it's a very, very common protest issue. There actually aren't that many sustained decisions of bait and switch because GAO kind of outlines what a series of specific things that have to be triggered in order for GAO to consider it a bait and switch. I mean, generally, whether the people that are identified in the proposal will in fact perform is not a protest issue. It's a matter of contract administration, and GAO doesn't consider it. I mean, so this goes to your question, Maureen, of, yeah, years have passed, people that you intended to propose at the time have moved on with their lives, now they're not going to perform. GAO is not concerned about that. I mean, that's the reality of government contracts, that you propose those people with every intent that they would perform, but then the agency took forever making award and they're not available anymore. That's not bait and switch. The bait and switch is triggered when the offer proposed personnel that it didn't have a reasonable basis to expect to provide during performance. They did not plan to use that person. So Lisa, if you don't mind going to the next slide.
Yes, of course.
So these are the three factors. So the awardee has to have either known or negligently represented that it would rely on that person and didn't have a reasonable basis to actually expect to provide them. So that's step one. And that's hard enough. I mean, can you imagine as a protester trying to have evidence that they knew that they wouldn't use that person? So it's a high bar already. But then also, you have to show that the misrepresentation was relied on by the agency and that it had a material effect on the evaluation results. So the bait and switch sustained protests come up where you got a significant strength or you got the highest possible adjectival rating because of this rock star proposal manager or program manager, and you knew that they weren't available. So if there's nothing in the evaluation record to indicate that the agency really cared about this person that you offered that wasn't going to be available, then it didn't have an impact on the evaluation. So GAO is not going to sustain the protest.
Right. And we talk about the departure of these people.
Yeah, and I think this is what really gives people heartburn and goes to Maureen's let it also has implications for the letter of commitment versus letter of intent. So if an offer, okay, let me try to lay this out as clearly as possible. You have to inform an agency of changes to your key personnel that happen after proposal submission and before contract award. So already, I can feel through the computer, everybody's like, oh no, this makes me really nervous. This happens all the time. Because the agency can then either reject your proposal for not meeting the material requirement of key personnel, or it can open discussions and allow everybody to submit new proposed personnel. So that obviously delays the procurement. They don't like to do that. It's not a fun process for anybody. The caveat there is it's a knowing requirement, right? I mean, you have to know that that person is no longer available. So what is no, right? Can you go to the next slide, Lisa?
Mm-hmm.
This is maybe a reason to consider getting a letter of intent, not a letter of commitment, because the firmer the letter is, the more obligated that individual is going to feel to let you know when they no longer intend to actually perform. And as soon as you get that email saying, hey, that contingent hire letter I signed, I'm revoking it. You have to tell the agency now. You have to. So to some extent, what you really want is to not know. You don't want to know that people have become available. Just find out after you've gotten the contract, and then you can deal with it from a contract administration side of saying, okay, our people aren't available. Here's what we're due to swap them out. So
right.
So I would love to end this debate because I feel like I have it every time. Right, LOC, when the government gives you an option, right, between an LOC or an LOI, which one is stronger and which one should be used if you're given a choice?
I mean, I would think just from a purely protest perspective, that letter of commitment is stronger. And so you should use a letter of intent.
Mm-hmm.
Now, from an evaluation standpoint, you might be exposing yourself to some risk. Even if the agency permits both, maybe they decide that there's some risk associated with the fact that you only had letters of intent, not letters of commitment. So you can't. I understand as a protest attorney, I'm always trying to tell people to avoid these worst case scenarios, but you're also trying to win. You're trying to get the best evaluation possible. So if you feel like the best way for you to compete with an incumbent or to otherwise take on a strong competitor is to have 20 letters of commitment, I understand that from a business perspective. But when you start getting emails that people have dropped off to other opportunities, then you're going to have another challenge.
And let's also talk about, so this is something that Amber and I have seen over the course of our careers too, where this idea of intent versus commitment, it sounds like commitment is, no, you committed, you signed a document that said that you would work for us, but you're saying right here, a rescission of the commitment letters. So you can back out of it. So is it not legally binding?
I mean, so we have a constitution. Slavery is not allowed in our country. I mean, you can't force anybody. You can't force anybody to work for you. That's just the reality of the situation. So if you took them to court and said, they were bound to work for me, perhaps there would be some monetary damages that you might be awarded, but that you cannot make a person work for you.
But is that really worth it anyway?
Right.
So.
Yeah.
Interesting. Okay, so that was key personnel. So now we're going to move into our final bucket of this hour-long training. And this one we're just going to call going above and beyond. And that's on the proposal side, especially as consultants. Man, I've seen companies, they love to provide more than what's asked for. And so we're here to discuss if there's a danger in including non-required information when it comes to protest. And the answer is yes. And here's some examples of something on the proposal side that we see all the time. And folks say, oh, we have a 25-page proposal limit for this. That's fine. I'm going to include an appendix. And in that appendix is where I'm going to discuss the requirements that they have asked for. That's a tough sell, because if you have a page limit right there, many solicitations will say that anything beyond that is going to get. Is it always? Of course not. Sometimes people will peek, but you definitely have a danger, especially if you put compliant information into the appendix.
Or reference it, right? Or cross-reference it.
Mm-hmm.
Exactly. Submitting marketing materials and pamphlets. This kind of goes along with the folks will just slap it in the back. And if it's not in the back, sometimes they put it in an executive summary where it's really like, this is the company X show, and I want to show you how great I am. You really have to brag, with caution. Sometimes it's too much because it was not asked for. So an executive summary is actually a really good example of that. I know some people always put an executive summary in a proposal, even if it hasn't been asked for. They'll have to put it in page count, most likely. It'll have to take up a page of the technical, the management, have you. But some people will skip right over that as well. And then writing narrative that you think the government wants versus what is being asked for explicitly in the RFP. This particularly happens with incumbents who we say have the burden of knowledge. They know the project, they know the contract, they know exactly what is happening on the ground day to day, but it's not being reflected that way in the solicitation. So instead of answering requirements A through C, they're going to give you, D through G, just off that way. So.
And something to add in there that you may not find to be going above and beyond, but something that Lisa and I just recently kind of encountered with an RFP was actually table of contents and a cover page. And we asked the government in Q&A during it was a 15-page technical. And we asked the government, will table of contents and a cover page be counted? Because it was an online submission. And, you'd like to have it look nice, right? As proposal people, we all get that. And they didn't answer the question the first round. So we continued developing the technical proposal and kind of kept pressing for an answer, assuming, right, cover page and a table of contents technically isn't counted. And we were thinking, we're like, okay, I think that's an easy, out of all the risks to take, this is a risk that probably will be okay, right? If they're not answering it, it will be okay. The day of submission, it was due at 2, it was like at 9 a.m. They put out their second round of questions, and literally in that response, they said that if you put in a cover page and the table of contents and any of the proprietary stuff, the stuff you put in the, the headers or the footers, that's going to count against page count. And we're like, okay. So, we quickly had to readjust the document, but don't always count. And this is a pretty well-known agency. This was not a semi-quasi. This is not one that you don't typically bid on. This is a pretty well-known agency. And it was a pretty, high level, high value rec. And so don't always think that, you don't think about table of contents and a cover page as going above and beyond. But here it would have been. Yeah. And they would have gone thrown out, and there would have been 2 pages out of their tech that would have been tossed, that would have deemed them non-compliant, and they would have, they could have lost. So just to me, that was kind of a wake up call where it's like, not everyone thinks that way. Right. And where you think going above and beyond may just be the administrative stuff in the front. If it's not obvious and you ask that question, always wait for an answer.
Right.
So this case, Intertech Aviation, I think is one that kind of makes people's jaw drop. And I want to note that don't think about page limitations. This isn't a page limitations case, because this case, page limitations aside, stands for the proposition that if you submit something with your proposal, the agency can evaluate it. I mean, even if it's an extra. So in this case, the RFP required resumes for key personnel with experience and degree requirements that matched up to the labor categories associated with those key personnel. The protester decided to provide additional resumes for non-key personnel who they thought were, they thought this was particularly strong and they'd probably get a strength. But instead, the protester was assessed weaknesses based on the fact that not all of those individuals met the labor category experience and degree requirements for the key personnel. And GAO denied the protest and said that the agency was within its discretion to evaluate these extras, according to whatever criteria was appropriate for the evaluation of those resumes.
And you've seen this. We've all seen this on proposals, because I know, especially big companies, they love to give the value add. They love to give you, these aren't key personnel, these are mission essential. We've all done it. You think you're clever by putting that in a proposal. Everybody writes that. So this is that mission essential. Ooh, look at this. It's not, and they'll think, the government's not paying for this. This is just people on our overhead. So we are going to present them as value add. And you're saying right here, no, ma'am, they were able to say this doesn't meet the requirements of the key personnel. And even though they're not key, how'd you go?
Yeah, I mean, and I think, this doesn't, look at this case from 1991. I mean, that's a long time ago at this point. It doesn't come up that often because probably in most cases, agencies do evaluate you positively for providing these extras. But you have to know that if the agency doesn't like something about these extras, it's not just that, it has to be disregarded. So it's a strength or it's nothing. It still has the potential to be a weakness. And GAO is going to allow that.
What about extras? And this is something that comes up in proposal development all the time. And on the strategy side, it's like extras are great, but when you see extra, you also see dollars and you see extra being expensive. So I can definitely see that rolling through, maybe in some protests too. Like, well, that's not what we wanted. We didn't ask for it. We got scared of it. So we pulled back.
And you're creating more work. I'd be mad about that.
Yeah. Agencies don't always do a good job. I've seen weaknesses assessed for proposing too many people, in a labor mix. So we have too many people in this category. And you're like, well, how is that a weakness if we were still cheaper than the awardee? The agency is just going to come back and say, it doesn't demonstrate understanding of the requirements. They're always going to find, if they decide that they don't find it beneficial and they assess a weakness, it's very hard to challenge that weakness unless it was unstated evaluation criteria or they applied it to you unequally compared to the other offerers. So the agencies just have incredibly broad discretion in doing their evaluations as long as they are complying with the solicitation and they're treating offers equally.
I was going to say, couldn't you say this doesn't show an understanding of the requirements? Couldn't you say that for pretty much anything? Like, that seems like a pretty easy catch-all, right? You didn't show me you understood. What do I have to do?
Yeah. And I mean, you go back to what the evaluation criteria was, right? I mean, sometimes demonstrating understanding is not what is supposed to be evaluated. Sometimes it is. So agencies do get in trouble sometimes using this broad language. You're like, well, you're probably going to lose your protest if you're making this argument. But you're like, well, we didn't have to demonstrate understanding. So again, like you're trying to show the agency whatever they said in the solicitation that they're going to be evaluating.
Okay.
Yeah, I mean, so I just gave a couple other examples here. Resumes are obviously one. Quality control plans, I've seen those submitted voluntarily. They're not a requirement, and all of a sudden the agency evaluates it and they hate it. And so you're going to get
30 pages of just like jargon.
Yeah, right. But you can say, look, we're showing you we do quality control, but you're giving the agency sometimes many pages of documents to look through and find problems with. So again, I can see how an offeror would think this would be a value add, but it's a risk. Same with org charts, teaming histories, extra past performance references. I mean, these are the kinds of submissions we're talking about when we're saying go above and beyond. And I mean, Lisa and Amber can go into whether or not this is a good business strategy and when. My purpose is just to note that these things can be evaluated, and so therefore they can be assigned weaknesses.
Yeah, well, on our side, it doesn't make sense. If they didn't ask for something, just period, point blank, don't give it to them. Just because you think you know what's best, it doesn't mean that you do. And I know that that's hard. Ask the question. That's what we've been harping on the whole time, right? If you think that you know your customer and you know that a quality control plan is important and it should be in the solicitation, one, if you're an incumbent, you should have already had conversations like this with your customer to try to influence and shape that solicitation before it was put out there. Two, if you know that you have something working on a project that you think that the customer really wants and you already talked to them about it and they still didn't include it as a requirement, guess what, buddy boy? They probably don't love you as much as you think that they do. Amber and I always say, the customer doesn't love you. Your mother loves you. The customer, you're dispendable. Dispensable. Like, it's just how it works.
Any given day. No, I mean, I think we deal with this all the time where clients are like, well, we can provide this and we have this plan and we have this software plan, right? And your 508 plan and, all the things that come sometimes with technical issues. And a lot of that can introduce some problems, as Elizabeth has been mentioning, right? A lot of these things kind of aren't well thought out or they have links in them that piss someone off, right? You don't want to send links in those things. So, what we always try to tell people is if it's not asked for, and it's like, they give you 15 pages and it really, we see this all the time, right? They give you 15 pages and in there it's a pretty comprehensive QCP. It might be because they only have enough bandwidth to get those pages. Giving them more creates more work, which will make them mad. But don't ever give an appendix where it's not asked for. If they reference appendices, ask the government what type of appendices they would like to see in Q&A. But, we always say it's not in your best interest. It's not in their best interest, because at the end of the day, you have to think about the files you're sending, the size of that, how many people are going to be reviewing that. And then if your proposal is being run through software, which a majority of them are, and, there's no keywords in those appendices, then it's not picked up on anyway. So you just send a bunch of junk over there without them even looking at it, and no harm, no foul, maybe. But, say it's protested and someone like Elizabeth comes in and says, well, did you look at all this? No, this wasn't fair. That can also create more problems for you.
Right.
Yeah, for sure.
So that concludes. We're about 5 minutes away from the top of the hour. We'll open this up to any questions. If anyone has something that wasn't covered today, like I said before, this was the second part in a series. You can see part one here. It's actually on our blog. We didn't have a recording of it, but Elizabeth was kind enough to write up answers to a lot of other legal questions when it comes to the protestable issues that we discussed in February. So feel free to visit that. So like I said, we got 5 minutes. Anybody have anything? Looking at the chat. We can just talk about other silly things that we see.
Everyone's eating their lunch.
That's fair.
Yeah, I hope so. Yeah, I mean, it's worth looking back just briefly at part one because there is some, we focused on some proposal compliance elements there. Specifically, we talked about page counts, formatting. So some of this is some overlap, right? I mean, when you're going above and beyond, you have to be compliant with all these formatting restrictions before you even get into, the strengths and weaknesses of the substance.
Ooh, best practices for assigning all of the compliance discovery. Who needs to find what? This is interesting because there is actually someone posted something on LinkedIn where the reps inserts in a submission were filled out incorrectly. And somebody on LinkedIn said the proposal manager should have caught that. You're right now, as a proposal manager, it's my job to make sure that that sort of contractual stuff is filled out, but it is not my responsibility to see if it's correct in terms of compliance sake. So you have to assign compliance discovery based on the content at hand.
Anything contractual goes to a contracts person or the owner of the company if you're working somewhere that doesn't have it, or they're legal. As a proposal manager, I don't care. I've worked with mom and pop shops that are 2 people small, or even when I've been internal, I do not fill out the contractual things, right? Those are things that you want to make sure that someone at a higher level or your contracts or your legal have looked at. I don't care how big the company is, if you're a consultant or if you're internal, it goes to somebody that deals with contracts.
Right. And I see another comment in here saying that these contract related responses should always go through a color team review to catch that stuff. Yes, absolutely. The eyes, the better. But what it comes down to is responsibility is on, it's given to the leadership, it's given to contracts. You'll definitely see things like an unsigned SF33 or the wrong box checked in reps inserts, like you've said. The more eyes, the better on this kind of stuff. But it shouldn't be all on one person. That's what gets me, is when it's like, oh, my proposal manager didn't catch this. And it's like, well, your proposal manager probably caught all the other things that were happening.
The proposal manager wanted to make sure it was done and completed, right? Like, that's what your proposal manager is supposed to do. Your proposal manager at that time is not wondering because you should know what box you're checking. As a contracts or as a business owner, whoever is actually filling it out, you should know what you're checking. And getting that. You can find your proposal manager hiding under their desk with some day wine. Yes, all the time, right? Especially now. But always, 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 always. I love the idea of sending it through a color team review. I think that's a great idea. And always send it out to contracts or the owner of the company or legal outsourcing every time. Don't take a risk with that.
And to the extent that any of you actually get involved with protests, I want to say how helpful it is as a protest attorney when I am given the opportunity to get on the phone with the proposal folks, the contracts folks, the broader business team. And those are the people that know about their own proposal, strengths and weaknesses, and likely about their competition. So, I always ask, I love to talk to GCs, but let's all get on the phone together so I can hear from the people that actually know.
Yep. Proposals are, a group sport, team sport. So we're all in this together. So with that, just about 2 minutes away from the top of the hour. So we want to thank you all so much for joining us. We really appreciate it. We're really glad that we got to do a virtual one of these. We were bummed when, coronavirus hit. And so we couldn't do another one in person. So, look out for the replay of this to be sent to your emails. We'll post the video online as well. Maybe we'll put out another Q&A like we did on the last one if we can convince Elizabeth to do it for us.
You got it.
We'll see you guys at part 3. Thank you so much. Have a good rest of
Thanks,
the day.
everyone.
Thank you, guys.